Bismillahirrahmanirrahim. Assalamu alaikum warahmatullahi wabarakatuh. My name is Ghulam Sajjad Gopang. I am MBA Finance first position holder from IBA University of Sindh Jamshoro. I am LLB first position holder from Quaid-e-Azam Law College Nawabshah Sindh. I am the first Advocate Supreme Court in the history of district Nawabshah Sindh, Nawabshah Bar Association District Shaheed Benazirabad, and I am the youngest advocate in the history of Supreme Court of Pakistan. Due to busy schedule of cases, I have shifted from Nawabshah Sindh and now I am settled at Islamabad permanently, and I am having more than 100 cases pending in 2 years practice before Honorable Supreme Court of Pakistan at Islamabad. My 28 cases are reported, published in PLD law books, and the latest one is 19 SCMR 2063. On special request of all you friends, more than 75 friends have requested me on Facebook and YouTube to deliver a comprehensive lecture on anti-corruption laws and anti-corruption cases. I would like to say that I am very sorry that I could not have time due to busy schedule of Supreme Court cases, and I am delivering this lecture after a delay. Anyway, today's lecture is regarding anti-corruption cases. There is a very wide scope and wide net of anti-corruption laws and corruption cases, and anti-corruption, provincial anti-corruption, federal anti-corruption, and then the NAB laws. I have delivered a lecture on NAB laws, and my next lecture will be a comprehensive one on the NAB cases. So I would try my level best to concise it in short time. Let's take a start with Section 5 of the Prevention of Corruption Act 1947. Unfortunately, in our judicial system and our police and investigation system, mega corruption scandals are being ignored, and people who are charged in 500 rupees corruption cases, 50,000 corruption cases, 1 million rupees corruption cases, they are being arrested and investigations are being done only because that the investigation agencies, unfortunately in Pakistan, are somewhere, not always. We have honest police officers, anti-corruption officers, NAB officers, police officers, but I believe, as I have been a police officer as well, unfortunately we have seen investigation officers as facilitators of corruption. Section 5 says criminal misconduct, and Section 4 is presumption where public servant accepts illegal gratification. Unfortunately, what happens is that without collecting any evidence, just to malign an officer, a government officer, inquiry is conducted in a wrong way, and without collecting sufficient material, FIR is lodged, and a person who is a government servant is least concerned with the material and the evidence, but more concerned with his wisdom, his honor, that he is an officer and now he is going to be sent to jail. What will happen to the social circle of that police, government officer, and about what will be happened with the family of that respectable person. So he is forced to pay illegal gratification to the investigation agencies, and therefore the real philosophy and the real target, that is to eliminate corruption from our country, is being demolished, and harassment culture is developed. So a public servant is said to commit the offence criminal misconduct. It is divided in 5 parts. First is that if he accepts or agrees to accept or attempts to obtain any person from him for any other person any gratification. It is very difficult to prove. It is very difficult to prove that I have paid this thing, this illegal gratification to a government officer. But anti-corruption officers do not work out on it. They just harass the public servant to obtain gratuity. I personally believe that anti-corruption somewhere, not always, we are very honest officers in anti-corruption department and great landmark achievements have been made, but somewhere I believe that they are not anti-corruption but they are anti-corruption. The anti-corruption department looks to be somewhere 10% or 20% anti of corruption, to promote corruption. In this regard, (2001) Pakistan Criminal Law Journal 161, 166 you have to study. In this, amount in question taken from the ground at the time of apprehension of accused. Then is conversion not heard by the magistrate and IO and accused acquitted 2004 YLR. Mostly there is no direct evidence in it. But again, the accused is being charged. Now, A, B, C, D and E. It says that if, now this was A, B says if he accepts, obtains or agrees to accept, attempts to obtain himself or any other person any valuable thing. This is also very difficult to prove. That if he dishonestly, fraudulently misappropriates or otherwise converts for his own use and property entrusted to him and under his control as public servant or allows any other person to do so. All the law that has been created and that is being operated is general. There is no specific provision in anti-corruption that, as I have recommended Farooq Naseem and other senior persons to have a legislation on NAB laws. Similarly, today I request the Law Ministry to have a legislation regarding the defects of anti-corruption laws, Prevention of Corruption Act 1947. It is totally defective. And public servant is very easy to be harassed by the anti-corruption officers. In this regard, you have to study. There are several judgments. I have a wide library. You might see at my background, and then I am fond of studying the books. And when I am at Supreme Court, especially yesterday, I was at Supreme Court at Islamabad in 2 benches, and I argued the case. I submitted several judgments, but the query which was put forward before me, query of Honorable Supreme Court judges very hard, and their experience is absolutely wide and spread, and it is very difficult for any advocate to satisfy such a caliber judge of Supreme Court of Pakistan. Alhamdulillah, we are having the best judiciary in the history of Supreme Court of Pakistan. All the benches and all the judges are very, very competent and very much relief giving as well, encouraging. But it is their duty to ask difficult questions. So they asked the question for me that Section 5 of the Prevention of Corruption Act is applicable to your case. I requested and I delivered a detailed lecture on this point, that I personally believe in as assistance. I tried to assist the Honorable Supreme Court, and on the point that Section 5 is totally defective and Section 5 cannot be proved. There is defect in the legislation, there is defect in the investigation, and there is totally malified in the proceedings of the anti-corruption cases. And when the investigation agency does not have a sufficient proof and direct evidence that this benefit has been obtained by the public servant and he is the beneficiary, then challan should be submitted. 2-3 years are spent in inquiries only to harass and grab money from innocent persons, and at the end of the day, if you cannot pay them, challan is submitted against you and innocent persons are being dragged into false litigation. So I requested during argument before Honorable Supreme Court, I submitted 5 judgments, and I am giving you as a gift 5 comprehensive judgments of Honorable Supreme Court in anti-corruption cases, which is covering almost all types of cases, because 406 of PPC, 409 of PPC, 467 PPC, 468 PPC and 471 of Pakistan Penal Code, these sections are mostly applied in such like cases. And definitely I will read out the sections that are not applying on it. Now 406, punishment of criminal breach of trust. Whoever commits criminal breach of trust shall be punished with imprisonment of either discipline may extend to 7 years. Now, what is criminal breach of trust? It is also very difficult to prove. A person who is a clerk is having a responsibility to issue checks. That can be charged under section 406. But a person who is engineer and is a civil engineer and has built a building and along with his team, and that building is handed over to the department from which, where the contract was signed, and there is a satisfaction report, handover report, everything is on satisfactory grounds, then how can that engineer be dragged in 406? 406 means a person who is having something in his hand and he has committed criminal breach of trust. So 406 mostly is not applied in the cases. Then is 409, a criminal breach of trust by public servant or banker, merchant or agent. Then again this is the same thing. When you don't have anything in your physical custody, how can you make criminal breach of trust in that? Now then comes 420. This is the appropriate section. Now what happens that anti-corruption officers are adding different sections with the main section 420, because 420 is bailable. Section 420 of the Pakistan Penal Code is bailable. So convert that bailable section into non-bailable so that the public servants should not be allowed bail by the honorable courts. The anti-corruption agencies deliberately, illegally, unlawfully, without any reason apply 406, 409, 467, 468 and 471 of Pakistan Penal Code, only to make the case a difficult one and convert bailable case into non-bailable so that the bail should not be allowed. And when the bail is not allowed to a public servant, that public servant will definitely surrender before anti-corruption, will definitely have no other option but to accept, to come to the illegal demands of the anti-corruption agencies to pay them illegal gratification. Because now I personally believe that when a person is public servant, is there any apprehension? This was my argument before the Honorable Supreme Court, that is there any apprehension that he will escape away? If there is apprehension, the passport can be secured, passport can be submitted before the trial court so that he should not leave the country. He is enjoying a salary, he is performing a duty, he is residing in government quarter where he can go. So on that ground, even on sole ground, I submitted before Honorable Supreme Court, and I used to submit before Honorable Islamabad High Court and several High Courts as well, that the best thing to deal the government officers and public officers in anti-corruption cases is to impose them to grant the bail in terms of huge surety, huge amount of surety. For 50 lakh surety, 1 crore surety, if he will escape, then surety will be forfeited. And when he is not escaping anywhere, yes, in one condition, if there is something to be recovered from that. For an instance, again 406, 409, 467, 68 and 471. Point is that if a person is having a record in his custody, financial record or anything which is very, very material in the investigation, and the anti-corruption proves that we have to recover this thing from that accused, then that public servant should be sent to the jail, and that thing is to be recovered. In other cases, except this, there is no any other legal ground to send a public servant to the jail. Now, this was the thing that I wanted. I personally believe the best judgments, I'm giving you five best judgments of Honorable Supreme Court on this subject. Number one is 2017 SCMR page number 77. It says that when there is no direct evidence and the accused is public servant, so there is no apprehension of absconsion from there is no any apprehension of absconsion of that accused. So 2017 SCMR page number 77, bail was granted by Honorable Supreme Court in anti-corruption case. Then 2014 SCMR 1628. 2014 SCMR 1628, public servant was bail granted on the ground that there was no direct evidence against him. And 2007 SCMR page number 843 and 1392, two judgments of 2007 SCMR 843 and 1392. And the last but not the least is very, very famous judgment PLD 2011 Supreme Court 509, that there is no direct evidence, and these 406, 409, 468, 469, 467 and 471 of Pakistan Penal Code are not applicable. So my humble submission to your friends will be to study these judgments, and if you need my legal assistance, call or SMS or WhatsApp me on my personal mobile number, cell number 0333 268 2662, 0333 268 2662. Subscribe my YouTube channel, like my page at Facebook, and share my videos so that every person who needs legal assistance will be very easy to approach, and we might help him as much as possible. Thank you very much.